If it pleases the court, my name is Salisbury, initials HM, and I appear for the accused, Mr. Marshall Ike. Your Honour, before we address any further proceedings, I wish to submit an application under Section 130 of the Evidence Act and Section 590AA of the Criminal Code for the exclusion of evidence against my client. Your Honour, there are 84 counts of breaking and entering and 1 count of stealing against my client, who is a 14-year-old Torres Strait Islander child. I request that the admissions made by Mr. Ike, obtained during the interview and questioning of him by the police, upon which the Crown's case exclusively rests, be excluded from evidence. Your Honour, in obtaining the admissions, there was a clear breach of the Police Powers and Responsibilities Act and the Responsibilities Code contained in Schedule 9 of the Police Powers and Responsibilities Regulations. Your Honour, police were called to a residence after receiving a call that my client had broken into the backyard. Police proceeded to arrest my client at the scene before putting him into the back of a police car, where they drove him around the neighbourhood, pointing out various burgled properties, asking, "Did you break into that house?" and "Is this one of the houses you broke into, Marshall?" Of which my client both nodded and verbally agreed. This, Your Honour, is a clear instance of gratuitous concurrence. Mr. Ike agreed to a succession of questions posed to him in an instance where the answer may not have been true, or he may not have understood the question. Further, Your Honour, the police officers did not inform my client of his right to remain silent. As such, the statutory requirements contained in Section 431 of the Police Powers and Responsibilities Act and Section 26(1) of the Responsibilities Code were not complied with. The police officers should have cautioned Mr. Ike of his right to remain silent, explaining that he did not have to say anything, answer any questions, or make any statements unless he wished to do so. Additionally, the officers should have confirmed that he understood this right. After my client was questioned in the police vehicle, he was taken back to the police station for formal interviewing. The interview forms the basis of the Crown's case. Section 421(2)(a) of the Police Powers and Responsibilities Act provides that a police officer must not question a child unless, prior to questioning, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child. While there was a support person present for Mr. Ike's interview, the social worker was not an independent person chosen by my client. This is a breach of Section 421(2)(a) of the Police Powers and Responsibilities Act. Your Honour, the police would have been aware that they were dealing with a juvenile. As such, my client should have been afforded the opportunity to speak to a support person of his choosing. My client could have had a parent or guardian present, but instead, he was provided with an unknown social worker and was just told to make sure he answered the questions the police asked. Additionally, Section 420 of the Police Powers and Responsibilities Act provides the regime for questioning of adult Aboriginal and Torres Strait Islanders. Pursuant to Section 420(2)(a), police officers must inform the person that a representative will be notified that the person is in custody for the offence. Additionally, Section 424(a) of the Police Powers and Responsibilities Act provides that a police officer must not question an Aboriginal or Torres Strait Islander unless the Aboriginal or Torres Strait Islander has been allowed to speak to a support person. Importantly, these standards govern the interviewing of adult Aboriginal and Torres Strait Islanders. Therefore, the standard would be even higher for children, entrenching the need for these principles to be adhered to. Your Honour, pursuant to the above submissions, there have been clear breaches of the Police Powers and Responsibilities Act and the Responsibilities Code. If we turn to the purposes of the Police Powers and Responsibilities Act, contained in Section 5 of the Act, it can be seen that the rules governing the police powers and responsibilities are, and I quote, to ensure fairness to and protect the rights of persons against whom a police officers exercise powers under this Act. Admission of the Crown's evidence would therefore be contrary to the purposes of the statute and as such undermine the principles of justice and fairness upon which the law is based. Your Honour, I ask that the Court exercise the Island and Bunning and Cross discretion to exclude the evidence led by the Crown on the basis that admission would be contrary to public policy. Notwithstanding the public requirement to convict those who commit criminal offences, there is a competing need to protect individuals such as my client from unfair and unlawful treatment. Here, the Crown's evidence against my client was obtained through explicit and willful breaches of statute by the police officers. The stated breaches, coupled with the presence of cultural issues, are, the defence humbly submits, sufficient to justify the exclusion of Mr. Ike's admission on the public policy discretion. As Your Honour pleases.